Last lecture in chapter 1, we talked about different classifications of the law. We said that the law can be substantive or procedural. Laws can be primary or secondary. We can have the civil or the criminal law. And we also classified court systems. We said that our courts can be in federal or in state, or they can be trial or appellate courts. And we're going to spend the time this chapter really focusing in on the court system and how each of those court systems work together and how they work independently. In the United States, we have 52 court systems. We have one for each of the 50 states, one for the District of Columbia, and a federal system. So we have the state systems, right? Each jurisdiction has its own state court system, and the federal system has its own court system. But federal courts are not superior to state courts. They're independent. So these are two different court systems that work at the same time in different ways and for different types of cases. For both the state and the federal side, the United States Supreme Court is the final controlling voice over all of these, each of these systems. We can classify courts in two different ways in the United States. The first is the distinction between federal courts and state courts, and the second is the distinction between trial courts and appellate courts. With respect to the first distinction and classification, remember that every jurisdiction gets to make their own laws. And also recall in our discussion of constitutional law that the federal government has power over federal issues and state governments have power over state issues. And so federal courts are going to govern federal issues and state courts are going to govern state issues. We're going to spend more time on this in the next coming chapters. With respect to trial courts and appellate courts, these two different courts are present in both the federal system and the state system, and we're going to talk about them and define them in the next slide. Our federal form of government has this balance of power between the federal government and the states, and that means that the federal government is of limited power in some capacity. And so because of this, we have jurisdiction or the power for courts to hear federal cases in limited circumstances. So those federal courts that we just talked about, they hear many, many less cases than state courts do. There are only two ways to get into federal court. The first is when a federal question is involved. So we call this federal subject matter jurisdiction. When a federal question is involved is when a case deals with a dispute that pertains to a federal matter. So a constitutional issue, so a claim that your First Amendment right to free speech has been violated, that is a constitutional issue and that would belong in federal court. Any acts of Congress, any federal law that is in question, those go to federal court based on federal question subject matter jurisdiction. The other way into federal court is by diversity of citizenship. Diversity of citizenship requires two things. So the first, it requires the parties in the lawsuit to be from different states or from the United States and another country. Okay, so that's that diversity element. That's what that means in this context. Diversity, the parties are diverse. They are from different places. In addition to that, there needs to be an amount in controversy or an amount that's disputed that exceeds $75,000. What this means then is that a party from California can sue another party from Colorado for a car accident if the damages exceed $75,000, and they can sue them in federal court. This is not a federal subject matter, right? It has nothing to do with the federal law. It has to do with negligence, which is state law, that's tort law. But because in the interest of fairness, we allow the parties to move that case to federal court because we believe that it is less of a home field advantage. If the California party gets to sue in California state court, that is a jury of the California residents' peers, the judge that sits on the bench that California resident got to vote for. So there's some home court advantage there. So in diversity, we allow that same case to go to federal court because federal judges are appointed for life. And so they don't have the same type of biases that we may find in a state court environment. So trial courts are those in which evidence is presented and testimony is given. Trial courts are what we see on TV. That's where you have a witness in the witness stand giving their testimony. You have lawyers questioning those witnesses and presenting evidence, maybe showing diagrams or showing videos or playing recordings. Those are trial courts. Trial court decisions can be appealed to a higher court, which is called an appellate court. Appellate court decisions can be appealed to an even higher court, like the state Supreme Court or the United States Supreme Court. On appeal, really the job of that court is to review what happened in the trial court. They do not hear new evidence. Instead, they review the record of the trial court and determine if an error has been made. In appellate courts or higher, so appellate or Supreme Courts, this is where we're going to see that concept of stare decisis being made. And then it trickles down to trial courts who are bound by those decisions as precedent. A party may also appeal the jury's verdict or any legal issue, motion, or court ruling during the trial. Once this appeal has been made, the appellate court is going to review the record from the trial court case. Once the appellate court reviews the case, it issues a written opinion that either affirms the trial court's judgment, meaning it agrees, reverses part or all of the judgment and remands, sends it back for additional trial, reverses part or all of the judgment and renders a new ruling or verdict, or the appellate court may modify the lower court's decision. This graphic here shows the two court systems that we have in the United States, the state system and the federal system. So the state is in the blue side here. So you have state trial courts that are at the bottom. They lead into those intermediate appellate courts and then ultimately the state Supreme Court. On the federal side, you have U.S. district courts, which are trial courts in the federal system. U.S. courts of appeals, which are appellate courts in the federal system, and then ultimately the United States Supreme Court oversees both sides, right? So it's possible for a case to be appealed from the state Supreme Court and make it to the United States Supreme Court, and likewise to be appealed from those federal appeals courts and make it to the U.S. Supreme Court. Although, as we're going to talk about, it is pretty limited in what the U.S. Supreme Court actually takes up. As you saw in the graphic in slide 5, federal courts are a 3-tiered system, very similar to our state court system, with those U.S. district courts on the bottom, then it's the U.S. Courts of Appeals, and then ultimately the U.S. Supreme Court. We're going to talk about those courts in the next few slides. So United States district courts are trial courts in our federal system. So if someone is going to be filing a lawsuit that has to do with a federal matter, they are going to be filing in a U.S. district court. Every state, District of Columbia, and then other U.S. territories have at least one district. Some states have more. In California, we have 4 districts. They're geographically based, so the bigger the state, the more districts they're going to have. The next level up on our federal system are these U.S. Courts of Appeals. So after that case goes to U.S. District Court, if the loser of that case wants to appeal, they will appeal to the United States Court of Appeals. So they hear appeals from federal district courts that are located within their judicial circuits. There are 13 circuits. So there are 13 United States Courts of Appeals. 12 of them are geographically based, And the 13th is a federal circuit, which has national appellate jurisdiction over things like patent, trademark, government contracts. Any case where the U.S. Is a defendant, those go to the 13th Federal Circuit. The next slide has a graphic that demonstrates for you the different geographic locations for those U.S. Courts of Appeals. As you see in that next graphic, you'll see that we in California are in the 9th district, and some districts are bigger than others, but all of those district courts that are within the circuits, those all go and get appealed to the particular numbered circuit that's in that geographic location. So they correspond geographically. So after the district court and the U.S. Courts of Appeal, on the federal side, we have the United States Supreme Court, which is the highest court in the land. It acts as an appeals court for all federal appellate courts, as well as state supreme and appellate courts that are dealing with federal issues. So if you look back at that graphic that showed the state system and the federal system, you know that the United States Supreme Court is the final controlling voice. It's the overarching court that makes all decisions. And so whatever decision the Supreme Court makes is binding, right, based on our system of stare decisis. It's binding on the state systems and on the federal system. In order to get to the Supreme Court, a party requests the court to issue a writ of certiorari, and this is basically just an order that requires the lower court to send a record of the case, so the transcript essentially, and the information so that the justices can look at it. Although it is the highest court in the land and it is the final controlling voice, they get thousands of appeals at the Supreme Court every year, and they take about 60 cases and issue even less than that in opinions every year. Before a lawsuit can be brought, there are specific requirements that need to be met, and the main one is jurisdiction. Jurisdiction is the authority of a court to hear and decide a specific action. In other words, it's the power of the court having power over the particular subject matter or over the person who is coming into the court. So there are a couple ways that we can classify jurisdiction. The first is personal. So personal jurisdiction basically means that a court is going to have jurisdiction over residents and businesses in its county or district. So for example, if you slip and fall at Ralph's on Lake in Pasadena, you can sue in Los Angeles Superior Court because LA County is going to have jurisdiction over businesses that reside in LA County. So that court would have personal jurisdiction over Ralph's, just like the court would have personal jurisdiction over you if you're an LA County resident. Subject matter jurisdiction is another type of jurisdiction that distinguishes if the court can hear the case or not. And subject matter is exactly like it sounds. It limits what the court can hear based on the type of lawsuit. So it's the authority of the court to hear and decide a specific subject matter of the lawsuit. Subject matter jurisdiction can be limited by any of the following. So the subject of the lawsuit, what is it about? These are things like probate or bankruptcy. Anything that has to do with bankruptcy goes straight to bankruptcy court, which is a federal jurisdiction. The sum in controversy. So in small claims court, we have the ability for parties to bring lawsuits for amounts that are less than $10,000. And so that amount in controversy is going to limit the particular court that can hear the matter. Whether the case involves a felony or a misdemeanor, so you've heard of drug court or traffic court, those are small courts that hear particular types of dispute. And whether the proceeding is trial or appeal, like we talked about last class, cases start in trial court, and then when they're on review, they are in appeals court, and there are actually different courts for those different judges that hear those appellate matters. So this power and authority for the court to hear matters, jurisdiction, can be classified in two different ways. We can say that a court has exclusive jurisdiction, which means that only one court has the power to hear the case. And we can also say that the court has concurrent jurisdiction, which means that more than one court can hear the case. So an exclusive jurisdiction, that could be something like bankruptcy. Bankruptcy always goes to bankruptcy court, and that's a federal court. And so that federal bankruptcy court has exclusive jurisdiction over any case that deals with bankruptcy. Concurrent jurisdiction, we can say diversity is a good example here. So we'll take our California resident suing our Colorado resident for a car accident.
In talking about the legal procedure of a case, it starts with plaintiff making a claim on existing laws and bringing that claim to court. The case will proceed through various motions and proofs, which is a submission of evidence, and arguments, which are debates about the meaning of the evidence and the law. The method of adjudication, the act of making an order or a judgment, comes from the judge. So the judge's decision has to be reasoned, based on evidence presented, and responsive to the evidence presented by each party, and it's typically in the form of an opinion. The plaintiff is the party making a claim and initiating the lawsuit in a civil case. In a criminal case, the plaintiff is called the prosecution, and the plaintiff and the prosecution has the burden of proving the case. The burden of proof in a civil case is called the preponderance of the evidence, which means that plaintiff's evidence has to outweigh whatever evidence the defendant can bring that casts doubts on the plaintiff's claim. Preponderance of evidence really just means more likely than not. So if we're talking about plaintiff presenting evidence, it needs to be 51%, right? Just more than defendant's weight of the evidence. In a criminal case, the burden of proof is much higher, and that's beyond a reasonable doubt. The plaintiff begins the lawsuit by filing what is called a complaint, which is a document that clearly explains the grounds for the suit. This is accompanied by a summons, which is a court document stating the name of the plaintiff, his attorney, and directing the defendant to respond to the complaint within a certain amount of time. This complaint is then served on defendant. Service of process, or to be served, is the formal notification of a court proceeding or a document. This is a really important process because without it, the court cannot exercise jurisdiction over a defendant. The court has to have proof that the defendant was properly served or properly notified of this lawsuit against him or her. The timing of the filing is also important because it's governed by the statute of limitations, which requires a lawsuit to be filed within a certain period of time. If it is not, the plaintiff is unable to bring that lawsuit, or the prosecution is unable to bring those charges.